Okay, Linda, you tried a case in Massachusetts. Are they just insane there? Is that the problem? Is everybody just wacky?
Well,
What's
the
going on?
slips, the jury verdict slips. I've never seen cases with jury verdict slips. The judge chooses the foreperson in Massachusetts. Yes, everything is different. The
I
wording is different.
I think
Yet
it should be
I get
called
fair jury.
it should be called the jury verdict slipped, not the slip. It should be the jury verdict slipped because that's certainly what happened in this case. So
Well, the
today,
jury
we got
didn't
new
slip though.
paperwork.
The jury didn't slip though.
That's the best I can do with the play on words. I'm sorry. So the new paperwork filed by the defense basically says we've got jurors who have talked to us either firsthand or second and third hand, and we've now learned that as to counts 1 and 3, the most serious, the murder-related counts, it was acquittal. It was basically we're not even getting to those. It's 12-0, not guilty. Let's move on. What's the problem with that, Linda? It sounds great. Is the defense going to be successful in basically getting declared acquittals on those 2 counts that was never really discussed in open court?
Well, after we appeal the judge's denial to bring the jurors in, because the vehicles for misconduct, right, to bring the jurors in, this is not misconduct. The jurors are saying, and I can't wait for all of them to get on the air together in some show, that we acquitted her on first and third, but we didn't know we could come out. And usually, Michael, in a case, and I've been there, the judge will say to the foreperson, have you reached a verdict on any of the charges, or are you hung on all of them? That's normally what a judge says. This judge didn't do it. And then what happened?
Yeah, she did nothing.
And
I see some waffle language here by the defense because my first thought was, well, why didn't Jackson or United say, excuse me, can we find out here whether or not there was agreement on anything? They never raised their hands, and there's some language in here that says this is the declaration of Alan Jackson at paragraph 7. The note, and we're talking about the final note where they said we're hung. The note was not presented to counsel for review. So to me, that's a little CYA language so that the defense can suggest that we didn't even get a chance to see the note. Therefore, we didn't get a chance to make that request or object to the court not asking the jury if they had come to an agreement on any of the counts. So how do you feel about this motion in and of itself? Gonna fly or not?
It's not going to fly at the trial court level. It's going to then go up on appeal, and it's going to go up to the Massachusetts, the head court of Massachusetts. And the case is not going to be tried in July as the state hopes, because this is going to clog everything up. Because she's going to deny bringing them in, right, Michael? And once that's an appeal issue of itself, if she denies bringing them in, how can you try it? How can you try this case, even on count two? Because now there's some suggestion that maybe there was bullying after the jury charge was read, the Allen charge on count 2. But the jurors seem to be in agreement with you and I that murder, there was no evidence of murder here. And that if she did hit him, she probably didn't even know she hit him. So you have a problem with that.
Yeah,
I can see.
So here's my problem with the motion, although I agree with the underlying facts. First of all, before anybody gets all ooey gooey over this thing, and that's a legal term there, Linda.
Ooey gooey? Okay.
This thing is replete with hearsay. The affidavits are hearsay upon hearsay upon hearsay. There are unidentified jurors, and I understand the reason for trying to maintain their anonymity, safety, fine. But from an evidentiary level, from a procedural level, you can't just be spouting off unnamed sources in an affidavit because it's inadmissible hearsay. I think that the defense is not so much thinking
I'm
they're
going to
going to
interrupt
win
you.
this.
Alan Jackson got called by a juror himself. Alan Jackson got called by, that may be hearsay, but he has direct knowledge, and he got called. So what's the thing? Bring the foreperson in. Bring the foreperson in if you don't bring the jurors in.
Even if fine, but as it stands on its face, that's inadmissible. It's irrelevant. I think the goal here is, yes, I agree that the judge is not going to fall on the sword and say, yeah, I screwed that up. No, she's not. She's going to stick to her, I did it right, denied, let's let the appellate court handle it. But I think part of the reason for putting this together the way they did, and remember, Unetti has not just an anonymous juror, but someone who talked to a juror. So 2 levels of anonymity and hearsay. But I think it's to say to the prosecution,
he's got confidential informants. If you're the prosecution, though, ultimately
yes, you're right. He's got a confidential informant who told a juror. Yeah, those are horrible evidentiary issues. But I think this is the message of this motion. They don't think they're going to win it, but they think the prosecution's going to see, we knew we screwed up. Everybody who watched the trial knew the prosecution screwed up. Now it's really being laid bare, and what are we going to do? Are we really going to go forward with this case or not? So I think it's
What
more
happens though?
message
Here's what
than motion.
what do you think the prosecution does here? The prosecution, if they were smart, would say, okay, we dismiss with prejudice counts 1 and 2, right? The defense is going to say, hey, no, we want a finding of not guilty, so that'll go up. But we dismiss with prejudice. In the meantime, the judge can say, all right, so let's go forward with counts 1 and 3. Let's go forward with count 2. If the prosecution were smart, they'd at least try that, and then the defense can say, hey, and then appeal the issue of whether or not counts 1 and 3 are final. Because if I'm representing her, I want a finding that I'm not a murderer.
Yeah, that'd be nice. And of course, it's going to come down to what the prosecution feels they have to do to save face. That's why they made that immediate statement. We're retrying this case. Well, now in light of this motion, which really lays bare what's going on, and they can get these jurors eventually. These jurors will sign affidavits. They will sign affidavits, and those will be admissible.
And then, I forgot too. So, we have the other thing on this. Okay, let me look at my notes here. Sometimes I get so excited, just like in a trial. The lead investigator, your Proctor factor.
Calm down.
Okay, this is how I'm trying this case, isn't it? Your
Proctor
factor. Well, remember he was moved to a different jury, and still pay, but now he's been suspended without pay. And my question is this. Were there some secret negotiations, things going on in the background during the time of this to try, let's not do anything now because we don't want to affect his testimony to say he's the lead investigator at the trial. And that could be, I think, a Brady violation if that was going on and the defense wasn't notified. Add that to your mix.
That's very interesting. I like the way. I think that's a unique version of a Brady violation, but on a more practical, I think. I'm not as smart as you, so on a more fundamental level, it's why would they hide this guy's disciplinary issues until after trial? Well, clearly so that at the time of trial, the defense doesn't say, so you were suspended because of all these activities, correct, Proctor? They saved that. Good save for the prosecution. But now for it to come out as it did in light of all these other problems, it's almost expected, Linda. It's almost like, of course, that's what this case is about. The inefficiency of the investigation, if not downright fraudulent investigation, and then the horrible decision to prosecute this case and charge as they did.
And now we have the issue of, because we forgot to mention those legal terms, double jeopardy on a retrial here. Yeah. So we have Brady, we have double jeopardy. Those two words our viewers know about, Michael. We have a lot to see in July, what's going to happen on the Karen Read case, and we'll be talking about it for a long, long time.